All right, we're back on the record. You're where you're still under oath, Mr. Massell?
Yes, sir.
Thank you. All right. You're where you're still under oath, Mr. Massell?
Yes, sir.
Thank you. Go ahead.
Mr. Massell, thank you for being here. Thanks for the information on patent law, more than I ever thought I'd know about patent law.
Thank you for putting up. Yes, sir.
I did want to follow up on one thing you mentioned about if you sue a supplier, you cannot sue the customer of that supplier. This has to be one or the other. My question is, if you, that wouldn't extend to other suppliers, correct? You could sue many different suppliers individually.
For each chain of commerce, you'd have to pick one or the other. But so it gets complicated if there's a vendor that also sells to a common customer with another vendor.
Okay, I'm going to use Exhibit 6, which is the draft settlement agreement between IBSC and Captain, because that's the one that's included, referenced, as far as I can tell, in the amended application of Desert, which is Exhibit number 43. I'll give everybody a chance to catch up. You have an interest in whether the board approves the 50-cent fee, obviously.
Yes.
Okay, so I'm gonna assume that you're familiar with the application, which is Exhibit 43. If you're not, you can correct me. Does the application include the 50-cent fee across the board, even on non-settlement participant operators? And when I say non-settlement, I mean the settlement under Exhibit 6.
I apologize. I have to go look at this quickly.
Sure. And if you want to go, I can point you to it under Exhibit 43. The page 4 of the document, not abates. Page 4 of the document. About halfway through the second paragraph, it says, if approved and authorized by this body for industry-wide application to be collected from a 50-cent augmentation to the taxi rate and remitted to patent holder as proposed by this amended application, et cetera, et cetera. So that's what I'm referring to when I say that the 50-cent fee requested in the application would be applied industry-wide and remitted to the patent holder.
Yeah, sorry, didn't mean to be so colloquial. Yes, I see that.
Okay. And I'm going quickly. I wouldn't have expected you to be able to flip those pages that quick anyway. So is it your understanding that patent holder would collect the 37.5 cents off of every ride, even from participants or operators who didn't participate in the settlement agreement?
So as we talked about before, this is all been a little bit of a work in progress. So when in March, when this amended application was filed, that construct hadn't been considered yet.
Well, I have to consider the application as it stands.
I understand that. So in the current context, regardless of when this was written, I think it was contemplated that if there was a way to patent peace where everybody gets the benefit of the 50-cent pass-through, that it would be crazy, not a legal term, I know, but it would be crazy not to sign up for the essentially free patent license.
Okay. Well, there are interveners here. So I guess my question is, if the board approved that 50-cent fee, 37.5 cents, which would go to IBSC, could you still pursue additional settlement or compensation with the non-participants of that agreement?
Yes.
Okay.
I believe we could.
Okay. At that point, would each party other than the current applicant and Captain, the software, the tech company, be expected to file additional applications to the board for additional pass-through fees after they negotiate it with you?
So someone who is not a party to one of the settlement agreements that we talked about earlier, I guess could come back and petition or to file an application for some additional fee. But the reality is that at that point, IVSC is probably going to be in a position to seek a higher royalty rate from the non-settling parties, which would include something in the range of that chart that was in my first pre-filed testimony. Plus, one of the things we haven't talked about is plus for willful infringement after the first meeting of the operators that that Captain hosted, the operators would be on the hook for potentially for willful infringement, which would entitle us to request of treble damages. So that's one of the reasons why I say it'd be crazy not to join in the settlement, because they get the protection of the 50-cent pass through without having to go through all of that additional litigation.
Okay. Those are all my questions. Thank you.
Thank you.
I'm going to ask the same question that I've been asking, and this is one of the things that's in my head. Is there another Captain-like provider anywhere in the industry, the world, that could provide a non-IVSC tainted patent product to run and be the same type of software and meter for cabs in Las Vegas?
Not that I'm aware of.
And why?
For the reasons that we've discussed a couple of times already. The IVSC patent reads to the statutory framework that I know does not apply to the taxi cab authority's jurisdiction, but certainly speaks to what, if any, software provider in the United States outside of Nevada wants to come to Nevada. It would be unusual, I think, for them to just focus on Clark County. They would probably try to get a foothold in the state as a whole. And if they did that, then they would be subject to that statutory framework that applies to the jurisdiction of the NTA. And it's clear that that statutory framework reads to the patent. So an operator couldn't comply with the law in Nevada, setting aside the detail about Clark County, could not comply with Nevada state law and not infringe.
You'd agree that there's regulated taxi cab industries in other states. You reference New York, you reference Philadelphia and other areas, right?
San Francisco, correct?
Okay. Are those jurisdictions subject to these patents?
Yes.
Okay. Have you sent demands to cab companies or technology providers in New York, Philadelphia, or San Francisco?
I believe there have been discussions that even predate my involvement with IVSC about the existence of the patents with those jurisdictions.
You know, I'm asking a specific question. I want to know whether or not demand letters have been sent to either technology providers or operators in those jurisdictions by IVSC, IP, LLC. Have they?
Not that I'm aware, not formal letters.
Okay. So tell me about, you said it's cost $36 million to, and thought I heard you say $36 million to, in the process to get the patents approved by the US patent.
Including developing the ride integrity application and the ride gene.
Can you start your answer over? I'm sorry.
including the development of the ride integrity software and the ride genie software.
So you're going back to the original R&D for parts of, at least, the product that was patented.
That's correct.
And how far back does that go?
Give you a pretty good time.
Yep.
I would say 12 to 15 years ago.
So when you were originally specifying, you talked about, I thought it was method and device. Did I write that down right? Two sides of what we're talking about here.
That's right.
Okay, so tell me, on a base level, what did IVSC provide to Captain? Is it both method and device?
So that's so initially, and I'm not talking about the patent itself,
Understood.
because the patent includes both
Got
method
it.
and device. I believe that that IVSC or Prius at the time shared its code at the time with Captain in one form or another.
And was that pursuant to an agreement or was that an NDA?
I don't know those details.
Okay. Okay. Appreciate that. So then in Exhibit 6, one of the things that I'm going to ask all the parties address is the new patent that came down yesterday and whether or not that's included in this, whether by law, by right, by whatever, you're going to need to talk about that in your closing briefs, I think. But as to the 5 that are listed on DC 028 of Exhibit 6, you had a question about whether or not the time to contest, not the right word. What's the right word, Mr. Messer?
The time to challenge the
Challenge. So has the time to challenge each one of these 1 through 5 on DC 28 run?
No.
Okay. When would those run?
It depends on the issue date, and there's some statutory provisions that apply to inter partes review or IPRs that are the way you challenge an issued patent. And I don't have the timeline on the top of my head. I will, though, answer the first part of your question, the foundational part.
Yes.
In the whereas clause,
Okay.
immediately below the listed 5 patents, it says that the licensed patents includes patent applications. That's the second and third lines of this. So the answer to your question is it includes anything that have issued or may issue on patent applications, et cetera, et cetera. So
I understand your position, and Mr. Tomlinson will probably argue that in the sense that this agreement put everybody on notice. But again, it's an unsigned agreement.
fair enough.
And I get it. I just want that issue to be addressed. That's one thing that I'd like to see addressed as we go.
Okay, I was trying to address your question.
Nope, I get it. I get it. And is it the position of IVSCIP that the challenge time is told once you send out a demand letter, like the Peacock letter?
The time to challenge that? No.
Okay. That's all I have.
Oh, you got one. I have one more. Go ahead. So the taximeters are in use all across the country. No one's, but through hardware and software vendors, operators, cities all across the country. IVSC achieved a patent on method and device And so now operators and vendors are potentially an infringement of your patent all across the country. My question is, do you think it's inevitable that someone eventually is going to challenge?
I don't know whether it's inevitable. I think most businesses, and this is really a business-oriented patent, act in their own economic best interest. And it may be that they decide that it's not in their interest to challenge the patent or to try to invalidate it in court. That it's just cheaper, and a lot of smaller companies do that. Just cheaper to enter a key settlement. And that's a strategy a lot of patent holders use.
Not cheaper for the public if they wind up having to pay the 50 cents, but I take your point. And thank you. That's it.
I don't know if you're the right person to answer this question, though.
Question is that.
I think I'll ask it later. That's all right. Anybody have any follow-up regarding the board's questioning of Mr. Missile?
I do, just a few.
Sure.
clarification questions.
Mr. Uriel?
Do you have the release and settlement agreement, Exhibit 6?
6. Yes, sir. Right here.
Just to clarify, if some service provider other than Captain, is it IVSC's position that a service provider other than Captain that agreed to those terms and entered into a master services agreement would get the same terms that Captain was provided?
I'm sorry, my only hesitation is when you threw in the and entered a master services agreement, because I don't recall that being part of the settlement.
Let me rephrase the question. Which is it IVSC's position that service providers other than Captain will have the opportunity to agree to the terms of what we have as Exhibit 6?
Assuming that this is the path that we go forward with, yes, but it is not the only option, I think.
But assuming that the present application is approved, is that available to other service providers?
So some combination of a settlement with the service provider and or a master services agreement with the service provider. We have a term sheet for that. And a settlement or license with the operator. Yes, everybody would be treated on an equal footing.
And the terms, monetary terms, would be the same.
Yes.
Nothing further.
Anybody follow up on that? Any redirect, Mr. Tomlinson? Okay, so I have a follow-up on that. So look at Exhibit 6, go to page 2, DC 029. The allocation of the pass-through fee, subpart C. That's where a master services agreement is mentioned several times. That is a master services agreement between each technology company and their operator, not a particular master services agreement between just Captain and its providers, right?
That's how I read this, correct?
Was that the intent of what was negotiated? Because we don't have a signed agreement, so I can ask you what you thought you were having IFSC enter in.
So to be honest with you, I thought that this agreement was superfluous and unnecessary. Because the terms that are here are already in that draft term sheet for the MSA between Captain, in that case, and IVSC, and also the license agreement between IVSC and the operators. This just overlaps with that almost %. So it was kind of yet another layer on top of what we had already done. And if this is the direction that the board wants us to pursue, then that's important to know so that we can accomplish this in the most elegant, cost-efficient way that promotes the public policy of doing things efficiently and in the interest of the public.
Okay. I don't have anything else. Anybody have any questions about what I asked? Okay,
Thank you.
thank you, Mr. Mason. Mr. Tomlinson, do you have any other witnesses? Okay. Mr. Scherer.
William George.
Okay. So the exhibits are in that green binder there next to you, Mr. George. All right. And if you'd swear him in.
Do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please state your name for the record.
William George.
Mr. George, did you submit written testimony in this matter?
I did.
And I would direct you in the exhibit book to Exhibit 25.
Yeah, something.
No.
That's it. Are you gonna question him?
I am,
Okay.
if I may. Ask him to
We
elaborate.
haven't been in the past. That's why I'm gonna leave it open to the other parties. We haven't been doing directs. If there is a proposed testimony. So does anybody have an opinion on that? Mr. Tomlinson standing up behind you, Mr. Scherer.
Would object just because I thought that at the outset of the hearing, we all agreed that the whole purpose of the pre-file was try to short circuit the long direct. So direct is pre-file, so just basically be reading the submitted testimony, which none of us got the opportunity to do that. So changing course here.
Yeah, I think it would be changing course. So what, you're gonna have the opportunity to ask him questions after everybody goes. So why don't we just do it that way?
I will note that Mr. Yorio was allowed to ask his witnesses to elaborate on their points in their written testimony.
And you will, and you'll be given that opportunity also.
Thank you.
Ms. Bremser.
Good afternoon, Mr. Joy.
Good afternoon.
My name is Pui Premsrut. We met remotely on your deposition. Pleasure to meet you in person. You've testified that you're the chairman and CEO of WHC Worldwide, correct?
Correct.
And you operate Z-Trip in Nevada?
We do.
But you entered Nevada only as of January 25th, isn't that correct?
In January
I'm sorry,
2020.
2025.
2025. I don't know the exact date.
So you've been in this community for less than a year, is that fair?
Correct.
And this was through the Bell acquisition?
We acquired certain assets from Bell Transportation.
So you have less than 1 year of operational experience in Nevada, Tennessee markets, correct?
Correct.
During your deposition testimony, you admitted that you did not prepare for your deposition beyond general industry knowledge. Is that correct?
Correct.
And you also testified that you did not conduct an independent patent review. Isn't that correct?
I did not have our outside attorneys do that. Correct.
So your testimony that Captain's system does not infringe is based on your belief and not on any expert legal opinion, correct? And unlike Captain, your opinion is not in reliance on counsel.
Correct.
In fact, you only learned about allegations when Desert Cab filed its application for this pass-through fee.
I learned about 2 weeks before we closed on our transaction from Brent Bell that there was an issue that he referred to, a dispute between a patent holder and CAP.
I believe during your deposition, you couldn't even identify or even explain what the exhibits were to Desert Cab's application. Do you recall that?
In terms of the patent,
I believe your testimony was you couldn't even identify what was attached to the application itself.
don't recall it that way. You were asking about the specific patent issues. That's what I couldn't identify.
I believe on page 14 of your deposition testimony, you testified that your review of Desert Cab's amended application was only cursory.
So, that's a different, that clearly is different than the question you asked.
But during your deposition testimony, you were not able to offer any testimony regarding the substance of the 5 IVSE patents that were listed in the application, correct? Okay, thank you. And you personally are not a patent attorney. And again, you do not have the ability to assess in detail whether these patents cover Captain's technology or not. You submitted pre-filed written testimony in this matter, and that testimony was derived from you personally having drafted bullet points for your attorney, correct? And you're aware that your pre-filed testimony and Mr. Jonathan Schwartz's pre-filed testimony are nearly word for word identical. Are you aware? And you inherited the Captain contract from Bell through an assignment. And you are relying on Captain's indemnification clause in that contract, correct?
We're relying on it, but we also no longer use the Captain system.
But as of the date of your deposition, which was July 2nd of 2025, Z-Trip was still using Captain's technology, correct? But Z-Trip did have notice of the alleged the alleged IVSE patent infringement as of January, correct?
No, Brent Bell explained that there was a patent dispute between a company, and I never heard of IVSC till the litigation or till the application between somebody who says they had a patent and Captain. So did not know of IVSC that till the Desert application came in.
And that application was lodged sometime end of February, beginning of March, is that correct? But yet Z-Trip was still using this technology irrespective of the publication of IVSC's threatened infringement claims.
Objection, this is all around. This is an attempt to litigate. Not to focus on the different case.
May I respond?
Yeah, what's your response?
Sure. This goes to Z-Trip's position and the basis that forms its position in opposition to the application. There was deposition testimony that this is not Z-Trip's concern because of Captain's indemnification. The point of my questioning is that it still had used the technology up until the deposition date. Therefore, there is exposure to which I don't think Z-Trip has conceded.
Yeah, I'll overrule it.
So as of July, Z-Trip was still using the technology through Captain, irrespective of notice of the IVSC threatened claims.
We heard about the issue 2 weeks before we closed. We weren't notified of an issue till the filing by Desert. And the decision was made to immediately no longer use the Captain system as soon as we could put a suitable replacement in, which we did in late July.
So your opposition is driven by your own transition plans, not by industry-wide risk management. Is that
No,
fair?
my opposition is, if you're asking my opposition to the rate case, my opposition is that I don't feel that it is competitive for our industry to add another 50-cent junk fee is what it gets perceived by the passenger. It makes us further anti-competitive in a market that is highly competitive. New entrants entering every day. That's the basis for my objection.
But your basis for objection didn't take into account the cost of patent litigation that could be anywhere from 3 to 4 million per case.
I think that's once again a huge stretch to believe. So far, I've heard the testimony correctly. IVSC is claiming that anybody using taxi cab meters and services around the country would be violating their patents. I do not believe that a $3 to $4 million expense, and I know nothing about what it would cost to do it, but it wouldn't be borne by just Las Vegas taxi operators. It would be borne by an entire industry that would come in and say that this is not a valid patent claim on what they've done. So it's speaking to the people in my industry association, that would be one of the big sponsors of a litigation fund to do this, would not be borne by Las Vegas operators solely. There would be a mass pushback against what is they believe to be a faulty claim.
But Mr. George, we're only speaking for purposes of this rate increase. We're only speaking about Clark County, correct?
But what you asked was if there was a patent lawsuit, there would be friends of the industry that participate in that. So the belief that it would be $3 to $4 million per case is wrong, because there would be a variety of people in the industry that would come in and support that to battle the allegation that the patents are being infringed upon by other devices. And I can't speak to the Captain technology, but from the assurances I've received from my other dispatch system providers, they are adamant. They've reviewed it and they're way more skilled at it than I am. They're adamant that there's no infringement with their systems.
So aside from your sort of representations that outsiders would come fund this litigation and mitigate litigation costs, there is an alleged $40 million of 6 years of back damages on the table, to which Z-Trip would only be a part of for less than 10% of that time, correct? Since you've only been at the table for less than a fraction, right? So you're not in the same situation as Desert Cab, correct?
Well, no, because I'm the largest taxi cab operator in the United States. So I do feel that I'm in the same position, probably a larger position than anybody else in this room. Because if the claims that are being made, litigation actually goes forward, I am very comfortable there will be a mass unified effort to defeat that litigation from everybody in the industry, in the taxi business and other people that this patent alleged infringes upon. So no, that's where it's.
I understand your forward-looking analysis, but in terms of where Desert Cab sits and these other operators of the Livery Association that you just recently joined this year, they're facing more damages than Z-Trip would ever face, correct? In the event that IVSC patents were upheld in this challenge.
I would, if that is the case, I would invite them to join me with other members of the industry that will put up a forceful defense against that. And we should probably share notes with your client.
But in all fairness, Z-Trip would gain a considerable market share if these other operators were to be forced out of business through if IVSC were to, or Mr. James were to make good on their threats.
Once again, I think that is leaping ahead so many different steps that I don't see it being feasible, because if you're saying it's an existential threat to the operators in Las Vegas, you're also implying it's an existential threat to every operator in the United States. And I don't think that has been considered yet. And I think if you're going to make those statements, you have to consider what the reaction would be to everybody involved. They're going to stop it before it gets that far.
While we're discussing threats, let's discuss the threat of Uber and Lyft. You've argued that a 50-cent fee would be harmful to the competitiveness vis-a-vis Uber and Lyft, correct?
Correct.
Okay.
And Zoop and Waymo and 15 other autonomous vehicles and other services that are all interested in coming into Las Vegas. Yes.
So wouldn't you agree that if IVSC were effective to eradicate many operators from this industry and bankrupt them through patent litigation, that would give Uber and Lyft a bona fide opportunity to come forward and absorb the industry outright?
While I am new to the Las Vegas market, I am aware that several companies in Las Vegas have gone through bankruptcy as a result of accident claims and other things, yet they've still been allowed to operate. There's other technology out there besides Captain that would allow them to operate. And I believe that there would always be operators who would come in if there were idle permits because of a bankruptcy. It would not damage the public because people would step in and activate those permits. So from a public standpoint, there would be, should be no risk whatsoever that they would not have adequate taxi service. And I've seen that in numerous cities around the country. Las Vegas would be no different. And there is proof of it in Las Vegas from companies that are operating through bankruptcy.
Let's talk about the public for a second. During your deposition, the convenience fee, or I'm sorry, the $3 charge that's permitted for the credit cards was discussed. And I believe your testimony was you were a proponent of that, and you distinguished between that fee and what we're doing here because it's a convenience fee, correct?
It's a convenience to use a credit card, and it's an accurate fee which represents the cost of not only processing the credit card and the technology, but there are high level of disputes, higher than most other cities, level of disputes against credit cards that have to be researched. So there's a lot of staff time that is compensated by that fee. Las Vegas has an inordinate amount because a lot of people in Las Vegas have taken cabs after they've been drinking, and then when 3 weeks later, when their credit card statement comes, they forget they took that cab and they protest the charge. So we've seen across in the short time we've been here, a much higher of chargebacks and disputed charges, and that fee helps compensate for that work.
Okay, so the convenience fee is for the benefit of the passenger, and you believe it's proximately related to the chargebacks and that cost? But doesn't the convenience of the Captain technology also benefit the public with shorter wait times? Isn't that something that technology helps the public?
We replaced the technology and we believe to be a superior service that is the same service, that the same technology we use all over the country. So I don't think that's an accurate statement. I don't think Captain brings anything to the table that other dispatch providers, or the taxi cab dispatch providers don't bring.
Yeah, but you were using it from January and 25 until July of 2025.
It takes a little time to change it out.
So there was still use by Z-Trip of the technology we established. With regard to the chargebacks and your example of, someone been drinking, et cetera, well, don't passengers also lose or leave items in the vehicles to which they need to go and retrieve them through lost and found? Isn't that a product or service that benefits the public that they directly use?
Yes.
Isn't it true the 50-cent fee amounts to approximately 2.5% of an average fare?
Average fare is mid $20 to $21, so that's about right.
The proposed charge that's the subject of this application, you understand that it would apply uniformly to all Clark County certificate holders, correct? Okay. And your recent change to a new technology service provider, you understand that that new service provider is eligible for that 12.5 cents, correct?
Yeah.
So every operator would be subject to not only that same pass-through fee, but the ability to select which Z-Trip has its own service provider, correct? Do you not understand that approval of this application would resolve past infringement for the entire industry, and you're still opposed to that?
I am.
No further questions.
Gregorio.
Afternoon, Mr. George. Robert Iorio. You indicated, I think, in response to a question that council asked you, that you had spoken to technology providers about whether different dispatch technology providers about whether their particular technology infringed the IBC patents.
Correct.
So those were discussions, oral discussions,
Yes.
and were there any expert opinions or patent opinions provided to you by any of the dispatch service providers that you had in mind?
I contacted MTI, AutoCab, and Curb. Three large providers, and two of them, or actually, I think Curb is international as well. So all three international, as well as iCavi, so the fourth one. They were aware of the allegations. I asked them to review it internally and let me know if they had any concerns with the products that they were offering us as we decided which system to go with, if there was any possibility of infringement or any valid complaints against infringement. They all four reported back to me. They've reviewed it on their end and they feel there's no infringement whatsoever in the services that they're offering, software product that they offer.
And were those reports back to you orally?
I think two were orally, two were by email.
And were the emails produced in this litigation or this proceeding? Excuse me.
Don't know if they were requested or not. I don't know.
Move to strike the witness's testimony about what he heard from other technology providers. It's all hearsay. To the extent there was any documentation, wasn't produced, and it's not an exhibit before this board.
Any motions to strike or anything like that need to be brought up in writing in a
Understood.
formal process. You could have raised those issues with with Ms. Swebb, and none of that was brought up. So you've raised the issue for purposes of what we're talking about here today. You can raise it in your closing brief and we'll consider it in terms of our opinion. If you want to file a formal motion, you need to go back to look.
Understood. The testimony he gave today was not in his pre-filed testimony, but we'll follow it up with him of Mr. George. Did you attend the first operators meeting that was organized by Captain on October 31 of last year?
No.
Were you invited to attend that meeting by Brent Bell of Bell Companies?
No. As
Sure about that?
far as I can recall. We had not even finished drafts of our deal by then.
And is it your testimony that you did not receive an invitation to attend that meeting, notwithstanding where the transaction negotiations were?
I don't have any recollection of that.
Recall attending operators meeting where you mentioned something about possible tenders to insurance carriers?
Tenders to insurance.
I'll restate the question. Do you recall attending any operators meetings? There were two, one October 31, one later, where the subject of insurance company coverage took place.
Auto liability insurance?
CGL, Comprehensive General Liability.
The only meeting that I've ever attended in Las Vegas with other operators outside of these meetings would be I met with Mr. Schwartz, and Mr. Balaban at the Four Seasons Hotel to discuss the LOA. It's the only time I've met other operators. I did have a prior meeting, maybe one or two meetings at Mr. Balaban's office a couple of years ago. But the only meeting I've ever had in person with operators is had drinks with Balaban and Schwartz, November, December, something like that.
Does E-Trip have a current comprehensive general liability policy in place? And have you reviewed that policy to see if there are exclusions for patent infringement claims?
I have not.
Is that something you intend to do?
No.
Nothing further?
Mr. Thomas?
Mr. George, for the record, my name is Neil Tomlinson. I represent IVSC IP LLC. I want to make sure that I understood your prior testimony just a few minutes ago here. I believe my understanding was that you were saying that if IVSC were to name you and other Las Vegas certificated carriers in a patent infringement suit, that you believe some other out-of-state companies not named in that suit would come to your rescue and write you a check for your defense. That
I believe there's been talk in the industry of doing a legal defense fund if a patent holder attempted to go through the service where people bought dispatch service and attempted to attack a service like mine, that other people in the industry would contribute to a legal defense fund to ensure that there was a robust and healthy defense against it.
and you think that even when they're not named in that suit, they would do that?
Absolutely. And I'm president of the Transportation Alliance, which is the industry association group.
Good luck with that, sir. Didn't you attend a meeting with Brent Bell where he asked you to join the LOA?
I had several meetings with Mr. Bell prior to acquiring his company, and one of them is when he told me about the LOA and who the membership was, and met Ms. Rushton as a result of those.
And wasn't that in 2024? It wasn't
Oh,
October.
I'm sorry, 2020 would have been. We didn't get involved in the acquisition of Bell till probably July of 2024. Were initial conversations and through another party that was acquiring the limo business. I don't believe I met Mr. Bell till late July, August 2024. And I had met Mr. Balaban about a year before that. And I met Schwartz. When I mentioned we had drinks, it was the first time that we had ever met in person. And I don't ever recall being in a meeting with Brent Bell, and Schwartz, and members of the LOA. Just the two of them, Mr. Bell, and the people on my staff.
So if we're bringing some people in here that say that you were at some meetings, was discussed, would they be lying or would you be?
Person,
Yes.
I have no knowledge of anybody being in these meetings other than what I'm telling you.
Is October 31st ring a bell?
Halloween.
Does that ring a bell?
No.
Okay. Let's talk for a minute about the $3 credit card fee that you mentioned earlier. How much of that is processing cost?
Depends on the fare. Processing is a percentage of the fare, usually around 3%. So it just depends on the fare. If you take the average fare of $20 and change, it'll be around 60 cents, I believe, is the math.
Okay, where's the rest go?
Equipment cost, chargeback cost, accounting cost. Fact that you're paying the drivers and then waiting for the money. So there's a bunch of costs that are relative to that.
So how much do you actually make on it?
We talked about this during my deposition, and now that we're 9 months into it, at best, we look at it as a break even, maybe a small profit center when you deduct out the chargebacks.
Isn't it true that it's more than 50 cents? The money that you get to keep of it, isn't it true it's more than 50 cents?
It depends once again on the fares and that, because it's a $3 flat charge versus a percentage that's charged by the credit card processor. But I would say max would be 50 cents.
No further questions.
Eric?
Good afternoon, Mr. George. My name is Jessica Guerra. I believe we may have sat like semi-close to each other at a board meeting. But I think this is our first time ever actually interacting in person. I just want to kind of clarify or maybe talk about some of the information that was discussed in your pre-file testimony as well as discussing your deposition. and what you've just stated here. So you stated that you are the largest operator in the United States. Did I understand that correctly? Taxi cab operator. Can you tell me what that means?
We operate almost 4,000 vehicles, 39 cities now across 20 states.
Can you give us some examples of maybe like some of your larger cities that you deal with?
Houston, Dallas, Indianapolis, Pittsburgh, Baltimore, Kansas City,
That's-
San Antonio,
Do those taxis operate on a metering system?
all of them.
And I'm going to assume, but please tell me if I'm wrong, do those metering systems use technology? And please remind me again, how long have you been in the taxi operating business?
48 years.
Congratulations.
Thank you.
And I'm just to clarify, how long within the 40 years of your, I guess, work life or your career, has taxis used technology?
We went to a computer dispatch system that was made by a company called Digital Dispatch, DDS. We installed that in the summer of 1997. So at least that long.
Now, if I recall correctly, during your deposition, you had not received any notices or demands that you are infringing on any patents. Is that accurate? Since July 2nd, I believe it was July 2nd of this year, since your deposition, have you received any notices or letters that you are in infringement of any type of patent work? And just to clarify, based on your discussions with your technology providers, they are confident that they are not infringing on any patents. And since we've all been in this room, I'm assuming you've been here for both days as well. And just so that I understand we're on the same page or have the same understanding, the IVSC patent in question, that is a nationwide patent. Does that sound accurate?
Understand it is filed with the US Patent Office, so it would cover all the United States, as I understand it.
And you share the understanding with me that enforcement of the IVSC patent would be applicable in any jurisdiction, not just Las Vegas.
Correct.
Yeah, no further questions. Thank you.
Mr. Sherrill?
Testified earlier, Mr. George, that you spoke to several different companies about the possibility of replacing the Captain technology in your Las Vegas fleet. Is that correct?
Correct.
Will you tell us which companies you spoke to?
Current providers, we call MTI. We are now switching our fleets to AutoCab. We considered iCabby and Curb.
And I think you mentioned that all of those represented to you that they had reviewed the patents and they did not believe that the technology they would be providing to you infringed the IVSC patents.
Objection calls for hearsay.
Could you ask the question again real quick? I'm sorry.
Could you read the question back, please?
came in a little bit on the last, with the objection, but I'm gonna read what I have. And I think you mentioned that all of those represented to you that they had reviewed the patents and they did not believe that the patent had been, that the patent that had been provided to you infringe on the patents. Sorry, might have been.
I'll re-ask it. So when you had those discussions with, that you testified earlier without objection to, about the potential of replacing your technology in your Las Vegas fleet, did all of those companies that you spoke to represent that they had reviewed the patents, the IVSC patents, and that they would be providing technology that did not infringe those patents?
That is correct.
Objection hearsay.
And did those, in their proposals to you, did those companies offer, or did they agree to indemnify you against any intellectual property claims?
Objection hearsay, best evidence rule. No documents or proposals have been produced.
Well, we have. I'm gonna overrule that. I think he can testify as to what his understanding as to what's included in the agreements.
As part of the request, I asked them for a copy of their contract that had the indemnification in it, very similar to what Captain's has in it. And most all software contracts that we sign have an indemnification clause in it that they have the proper license and ability to sell us the technology that they're selling.
And you entered into an agreement with, I believe you said AutoCab?
Yes.
And did AutoCab agree to indemnify your company against infringement claims? In paragraph 18 of your testimony, you state that I believe the amount of the proposed license fee and accompanying rate increase is excessive and would be detrimental to the taxi cab industry and the traveling public. Can you explain to us why you believe that?
Our total cost for the entire technology suite that we're provided by AutoCab for all 4,000 cabs nationwide is $61,000 per month. So we're going to pay somewhere around $730,000 a year for all of our vehicles, for all the technology,
How many vehicles did you say that was?
just shy of 4,000.
And if I'm doing the math correctly, there were, I believe, 13 million taxi trips in Las Vegas in or in Clark County in 2024.
I think it was closer to 12 million, but in that range,
So at 50 cents per trip, that'd be more than $6 million per year.
about 8.5 times what we're paying for all of our cities nationwide.
And in fact, the 12.5 cents that would go to the technology provider, if I'm doing the math correctly, would be just a little over $1.5 million.
About double. Pay.
And that technology that you're paying for, is it equivalent to the Captain technology?
Superior.
Objection, also an expert. And you,
True response.
I'm simply asking for his opinion as a taxi cab operator of how it functions and whether it meets their needs.
What was the question? Because I heard something a little different. That's why.
Question. And that technology that you're paying for, is it equivalent to the Captain technology?
Overall, you can answer.
The system, both the MTI system and the AutoCab system were superior to what we saw when we did side-by-side comparisons to the Captain system.
Did you compare the features of each system?
Yes.
Thank you. I have no further questions.
Ms. Primser? I'm just gonna go.
Just had one point that was brought up to me. You testified that the $3 credit card charge fee was not a moneymaker for you.
That closely resembles the cost. It's, yeah,
And you also stated that 50 cents was probably the highest you've ever been paid out of that fee.
Correct.
So you aren't aware of any payment or agreement where you received $1.80 out of that fee?
you say me.
I'm sorry, Z-Trip? Received that as a portion of the $3 fee?
I understand. You asked, is it a moneymaker for us? That is gross revenues coming in. There's a lot of expense that is involved in processing credit cards.
So when you testified that 50 cents was the highest you ever received, that was incorrect, right?
You know, I believe he was asking the question about if you made a profit off it. So when you take all the related expenses, 50 cents would be the max you could consider as a true profit. You have revenue coming in, you have expenses that are tied to that.
And the 50 cent pass-through fee that's proposed, which is 37.5 cents, and then 12.5 cents, that's not a share profit to either IBSC or the service provider, right? They're going to have to fund their own operational costs out of that.
Yes, I don't know what the is.
Thank you.
Mr. Iorio?
Yes. Question. Your testimony there includes exhibit
25.
25.
I do.
Look at paragraph 13 at the top of the second page. Would you read that into the record, please?
As a result of our national experience, I believe that there is other technology available that is non-infringing and would provide Z-Trip substantially similar functionality at a fair price.
And I understand from your testimony today, you believe that there's other technology available that is superior to Captain's. Is that your testimony?
Yes.
Is there a reason why you did not include that statement in paragraph 13 of your pre-filed testimony?
Not sure I understand the conflict between what I testified to and what that statement was I just read.
If you believed from what you heard from technology providers other than Captain that they had a superior technology, why didn't you include that statement in your pre-filed testimony?
I'm going to read my testimony again because I'm not sure. As a result of our national experience, I believe that there is other technology available that is non-infringing and will provide Z-Trip substantially similar functionality at a fair price. So you're saying that I left out the word superior?
Saying today you are going beyond paragraph 13 and making statements that you've heard from other technology providers that their technology was superior to Captain's.
No, I'm saying it's superior as an operator that uses the technology, that I did a side-by-side comparison of what was offered by Captain, iCabby, AutoCab, and Curb, and found that both MTI and actually all of them have superior technology in terms of what we use it for our operations.
That's your testimony today. It's not in your pre-filed testimony. Why?
I'm not going to parse words with you over whether it's if you're asking if I should put in the word superior, substantially similar functionality, or superior at a fair price, we could put in or superior. I'm not sure I understand the parsing of the words.
One of the purposes of pre-filed testimony is to submit whatever you have to say about this proceeding and the technology involved, and then appear for deposition. And if you had gone through these side-by-side presentations and had the view that you've described today, why didn't you include it in your pre-filed
I
testimony?
think if you go to my deposition,
Argument, if it mischaracterizes the definition.
I am going to say it's a little argumentative at this point. I get the point. I think both of us get the point. So I'm going to sustain the objection as to argumentative. And you can ask your next question. Mr. Chair.
Fair enough. I just want to make clear about the operator meetings. There were 2 meetings and you told me you were not at the one on October 31. Is there a second one in December that you may have attended remotely?
I don't recall. I can look at my calendar. If you can give me a date.
December 16th? You could.
Look at my-
That's okay with your counsel?
Sure. Let the record reflect that Mr. George is looking at his phone. So,
My phone is showing no events in December, which is not good. Because I travel.
There would have been some events.
Yeah, that's,
It's fair to say you can't say one way or the other.
I travel every week, College
something
City.
just popped up.
Your calendar just popped up.
Oh, it did. It's just. It's on here. There was a meeting on that I was invited to on December 16th at Desert Cab, which I was not in town because I was in a mediation in Kansas City at the same time.
And I can't see your phone, but I take it at your word. Were you able to attend part of the meeting remotely, notwithstanding your attendance at the mediation you described?
If I did, I don't recall because I have a mediation that I was in, and then I had an 11 o'clock meeting right after, which would have been 9 o'clock Las Vegas time.
Understood. So you just can't say.
I can't say.
It's fair enough. Thank you for your time. Appreciate it.
Mr. Tomlinson?
Again, for the record, Neil Tomlinson on behalf of IBSCIP LLC. Mr. George, what email do you use to accept calendar bites on?
WMJordan@ctrip.com.
Mr. Vice Chair and members of the board, I would request that this witness be made available tomorrow. I think we've got some concerns that have been raised here about the witness's credibility that would need to be addressed and cannot be addressed today.
It's been stated that he's only available today. So today and tomorrow, the days and times for it. He's presented himself here today. If you've got questions, ask him, would be my suggestion.
Would we be able to address this in our brief in some respect with?
Yeah, I mean, certainly you can address any issues that have been raised. If you think that there's a gap in time, I get it from the questioning. I think Redecker gets it. Whether or not Mr. George attended the 31st or the 16th meetings, we can go from there. I mean, you're going to have, the applicant's going to have the opportunity to call witnesses at the end of this. So there you go.
Fair enough.
I would ask, I share that they're going to submit additional documents that they provide those against on the brief, so they have not paid even comment on it.
I haven't authorized any additional documents other than the documents that have been presented in the exhibits for this hearing. And that the record is the record. So we're here, everybody exchanged documents. The exhibits are what they are. This is what Chair Reeser was talking about yesterday. We had a long process of discovery where everybody was asked to provide information. It was provided. If there was any thought that there were additional information, including emails and that sort of thing, there was a mechanism in place where people could have filed motions to compel or other things. So I'm going to say that generally, but yeah, you can address these issues and we'll consider them.
We come into this expecting people to tell the truth. They're under oath. So when feel that they're not, then it causes a problem. So you don't do discovery on expecting that. You can't do discovery.
You guys have all been doing this a very long time, so you all understand that there's other ways and other avenues that can be addressed as we go through this process. What I'm saying is the record for purposes of us making a decision is going to be testimony and proceedings today, the exhibits that were presented, and the applications and the briefs that were before the hearing and now after the hearing. So I don't think I'm saying anything different, but just making sure.
I think the concern is that there may be some items that would be helpful for purposes of impeachment only, and because Mr. George will not be available after today, that Mr. Tomlinson and presumably Captain's Council are foreclosed from providing those items.
I'm not necessarily saying that they're foreclosed. We still have a special master, hearing master that's in place regarding this provision.
Understanding.
If there's anybody that wants to address it that way, there's procedures to address it that way. But the other thing is that in Mr. George's testimony, was he asked about the October 30th or the December 16th meetings? Yes. That's one thing that I think we're all going to think about if it was or it wasn't. There you go.
Can I offer, since my credibility has been questioned here?
Nope, you can't. Your attorney can ask you questions and then we can go down that road. But so let's see, where are we at? Everybody was done asking questions? Subject to, oh, yes, Ms. Guerra still gets to ask questions.
Oh, I'm not sure if they're done. I know it was next in line, but I wasn't sure.
Nothing further.
Thank you, Mr. Sorry, Ms. Guerra.
No worries. Mr. George, I just want to, and I apologize, I didn't ask this earlier, but I think it goes to the questions that Mr. Shear asked. Because you have all these operations in other jurisdictions, can you give us an idea of, at least in your experience, where does Las Vegas or Clark County fall as far as base rates are compared to other jurisdictions?
They're all over the board. Cheapest rates in our system that I'm aware of on a per mile in the flag drop, the drop fee. The low end is in the $3 range. The high end is $6. Some places have a flat rate, like we have a contract at Dulles Airport that only our 400 cabs operate out of Dulles Airport. There's a $20 minimum charge, but that's what it costs basically to get off the airport. The highest per mile rate, I think, is in the upper threes, but $2.80 to $3 a mile is the general average everywhere. So trips in Las Vegas typically are shorter than what we see in a lot of our shorter mileage than a lot of our jurisdiction.
So if I had to do like Las Vegas is number 5 compared to your 39 cities, something kind of like that.
I can't tell you off the top of my head today because quite frankly, they all run together, but I
Okay.
could certainly price out a 5, 10, 20 mile trip in all our cities. That's something that we do have the data available on. I just can't speak off the top of my head.
Okay. It was also discussed earlier at the onset of this hearing yesterday that there may have been a possibility of you wanting to file an intervention. Can you please explain to us why you didn't intervene in this case at all?
We had just entered the market at the end of January, and I believe this came out in February, if I'm not mistaken, and we were new to the process in terms of intervening. Typically, the LOA would have been responsible for that, but because it would have been interfering against one of our partners in the LOA, it wasn't brought up as an option. So that's why we didn't. In hindsight, should we have? Yes. And that's why we participated with the other interveners, Kurt and Taxi Management.
No further questions. Thank you.
Redirect?
Reread?
Reread?
Mr. George, let's deal with the first one. Do you ever accept a calendar invitation and then not attend the meeting?
I will admit that I do.
What do you recall with regard to the October 31 meeting and December 16th meetings you've been asked about?
I had an opportunity to look at my calendar when we looked up the December 16th meeting and October 31st. I was on a plane from Kansas City to Phoenix. So I don't recall attending, there's no way I was in a meeting in Las Vegas on October 31st. I've got the flight receipt right here. To be happy to provide. I did have that other one on my calendar on 16th. Earlier I was in Kansas City because I was in a mediation. I don't recall attending remotely.
Is it possible that you may have attended some small portion of it remotely?
It's very possible.
When you submitted your pre-filed testimony, had you completed your side-by-side analysis of the different technologies you were considering?
We had not signed the contract yet, but we knew we were going to go in the AutoCAD direction.
Had you reached a conclusion as to whether the products were superior?
It was
That point.
Injection, bleeding, and hair center.
Also standing.
At what point did you determine that the AutoCAD technology was superior?
Injection, hearsay, and leading.
I'm asking when he determined it.
Yeah, no. Overruled.
We had several members of our team, from our tech people, data scientists, our operations people, our marketing people, all had representatives on a committee internally to evaluate all of our software options, and it was a unanimous recommendation that AutoCAD came out ahead of everybody that we looked at, including Captain.
So before we leave this, the question was, when did you make that determination?
We signed the contract with. I'm trying to remember the date from when it was presented to me to when we signed the contract, because there would have been about a 3 or 4 week lag between those two. I think we signed the contract in late June or July. So decision would have been made 3 or 4 weeks ago prior to that to negotiate exclusively with AutoCAD. So somewhere in that time period.
Sometime.
I would move to strike this testimony as being. Didn't. I don't know. Would have occurred after the time that he's just mentioned.
I'm asking about the questions that were asked by Mr. Yorio on cross-examination. Asking him to explain what happened.
I'm going to deny the request.
So that would have been sometime in July.
June, July. Somewhere.
I have no further questions.
Anybody that gets up and asks any more questions of Mr. George are going to be limited to what Mr. Scherer just asked. You need a reason?
Yeah, members, I want to propose maybe a 2-minute recess that looks, or at least maybe 2 to 3 minutes, because it looks like they're looking for a document, and I could use the bathroom break again. I'm very.
And that's fine. We've been going for that amount of time. We're not, this is not an endurance test.
Okay.
Yeah, we'll go off the record.
Thank you.